Welcome to the AskJunior Daily Judgment podcast. I'm Priya Mitchell, and joining me today is my colleague Arjun Kumar.
Hello, everyone. We're excited to dive into today's important judgment. But before we begin, don't forget to like, subscribe, and share our podcast if you enjoy our daily legal breakdowns.
That's right. Your support helps us reach more listeners and continue providing in-depth analysis of the latest court decisions. Now let's get started with today's fascinating case. It's a review petition that has significant implications for customs law enforcement in India.
Indeed, Priya. Today we're discussing the review petition number 400 of 2021, Commissioner of Customs versus MSS Canon India Pvt Ltd. This is a landmark case that essentially redefines the jurisdiction of the Directorate of Revenue Intelligence, DRI officers in customs matters.
Before we dive into the specifics, let's give our listeners some context. The case revolves around whether DRI officers have the authority to issue show cause notices under Section 28 of the Customs Act 1962. This might sound technical, but it has huge practical implications for how customs enforcement works in India.
Exactly. The controversy started with a previous Supreme Court judgment in the Canon India case in 2021, which had effectively curtailed the powers of DRI officers. That judgment had created quite a stir in the Customs Administration.
Let's break this down systematically. First, what's a show cause notice and why is it important in customs matters?
A show cause notice is essentially a formal document asking an importer or exporter to explain why action shouldn't be taken against them for alleged violations of customs laws. It's like getting a notice saying, "We think you haven't paid the right amount of customs duty. Tell us why we're wrong."
And the key question here was, who has the authority to issue these notices? The original Canon India judgment had said that DRI officers couldn't issue these notices because they weren't proper officers under the law.
That's right. The original judgment had created a rather restrictive interpretation, suggesting that only those officers who had done the initial assessment of goods could issue these notices. It's like saying only the teacher who graded your exam can question whether you cheated, even if another teacher caught you in the act.
But today's review judgment completely changes that understanding, doesn't it? Let's discuss the main findings.
Yes, the Supreme Court identified several errors in the original judgment. First, it found that the original bench wasn't made aware of several important notifications, particularly Circular Number 499, dated 15.02/1999, and Notification Number 44/2011, which had explicitly empowered DRI officers to issue these notices.
It's quite significant that these notifications weren't considered. It's like making a decision about someone's authority without looking at their appointment letter.
Absolutely. The court also found another crucial oversight. The original judgment didn't consider the significant changes made to Section 17 of the Customs Act by the Finance Act 2011.
This is a really important point. Could you explain to our listeners what changed in 2011 and why it matters?
Of course. In 2011, there was a fundamental shift in how customs assessment works. Before 2011, assessment was primarily done by customs officers. But after the amendment, a system of self-assessment was introduced, where importers themselves assess the duty payable.
So it's like moving from a system where teachers grade all papers to one where students first grade themselves, and teachers then verify or modify those grades if needed.
That's a great analogy, and this change had a huge impact on how we should interpret the whole scheme of the Customs Act. The original Canon India judgment was applying pre-2011 logic to a post-2011 world.
The court also made an interesting observation about the difference between Section 17 and 28 of the Customs Act. Can you elaborate on that?
Yes, this is crucial. The court found that these sections serve different purposes. Section 17 deals with assessment and reassessment at the time of import, while Section 28 is about recovering duties that weren't properly paid or were refunded by mistake. They're separate processes with different objectives.
And the court rejected the idea that only officers who do assessment under Section 17 can issue notices under Section 28.
Exactly. The court said there's no inherent link between these functions. It's like saying only the bank teller who accepted your deposit can investigate if there's a problem with your account later. It doesn't make practical sense.
Let's talk about another interesting aspect: the court's interpretation of the term the proper officer. The original judgment had made a big deal about the use of the definite article the.
Yes, this is fascinating from a legal interpretation standpoint. The original judgment had said that using the proper officer meant it had to be the same officer who did the initial assessment. But today's review judgment says that's not correct.
How did they explain it?
The court explained that the proper officer simply means an officer who has been properly empowered to perform that specific function through appropriate notifications. It's not about being the same person who did the assessment, but about having the legal authority to act.
This makes me think of another important aspect of the judgment: the court's analysis of Section 6 of the Customs Act. The original judgment had said DRI officers needed special entrustment under Section 6, right?
Yes, and this was another major error that the review judgment corrected. The court explained that Section 6 is actually meant for entrusting customs functions to officers from completely different departments, like police officers or border security forces, not for DRI officers who are already customs officers.
I think our listeners would benefit from understanding the historical context here. Could you explain how DRI fits into the customs structure?
Of course. The judgment provides a fascinating historical perspective. DRI has been part of the Ministry of Finance since 1957, except for a brief period between 1970 and 1977. They're not outsiders to the Customs Department. They're very much part of it.
And the court found evidence of this in various notifications, correct?
Yes, particularly in GSR 214 and GSR 215, which appointed DRI officers as customs officers way back in the early days of the Customs Act. This history completely undermines the argument that DRI officers needed special entrustment under Section 6.
Let's talk about something that might concern our listeners: the issue of multiple officers having jurisdiction. Some might worry that this could lead to harassment of importers.
That's a valid concern, and the court addressed it directly. They noted that the Customs Department has had a policy since 1999 that once one proper officer issues a show cause notice, other officers can't issue notices for the same matter. It's like having multiple police stations. Yes, they all have jurisdiction, but once one starts investigating, others don't interfere.
The judgment also deals with some constitutional challenges to Section 2811 of the Customs Act and Section 97 of the Finance Act, 2022. Should we delve into those aspects?
Yes, these constitutional challenges are quite interesting. Section 2811 was introduced in 2011 to validate past actions of customs officers, and Section 97 of the Finance Act, 2022, was another validation provision. Both faced constitutional challenges.
Let's break down the challenge to Section 2811 first. What were the main arguments against it?
The challengers argued two main points. First, they said Section 2811 conflicted with Explanation 2 to Section 28, which deals with cases before April 8, 2011. Second, they claimed it would create chaos by giving multiple officers jurisdiction over the same matter.
And how did the court respond to these arguments?
The court rejected both arguments. It found that Section 2811 and Explanation 2 operate in different spheres. Explanation 2 deals with the time period for recovery of duties, while Section 2811 deals with the authority of officers. There's no real conflict between them.
That makes sense. It's like having one rule about when you can file your taxes and another about who can audit them. They're related but separate issues.
Exactly. As for the chaos argument, the court pointed out that there was no evidence of multiple officers actually issuing conflicting notices, thanks to the department's internal policies.
Now, let's talk about Section 97 of the Finance Act 2022. This was quite controversial, wasn't it?
Indeed. Section 97 was a sweeping validation provision that essentially said all past actions by customs officers were valid. The challengers argued this was an attempt to overrule the Supreme Court's Canon India judgment through legislation.
That raises an interesting constitutional question. Can Parliament validate past actions that courts have found invalid?
The court addressed this by referring to earlier precedents about validation laws. They said Parliament can validate past actions by removing the basis of the court's judgment, as long as it has the power to make such laws in the first place.
And in this case, they found the validation was valid because it wasn't really overruling any finding of fact, but rather clarifying the legal position about the authority of DRI officers.
Exactly. The court found that Section 97 wasn't trying to change any factual findings, but was clarifying the legal framework within which DRI officers operate. It's like Parliament saying, here's what we always meant the law to be.
One interesting aspect of the judgment is how it deals with pending cases. The court gave quite detailed directions about different scenarios, didn't it?
Yes, this is incredibly practical and helpful. The court outlined 6 different scenarios and provided specific guidance for each. Let me break them down.
Please do. I think this would be really valuable for practitioners and affected parties.
First, for cases directly challenging show cause notices in high courts through writ petitions, these should now be disposed of according to this judgment and the notices restored for proper adjudication. Second, where high court orders are under appeal to the Supreme Court, these appeals should be decided based on this judgment.
And what about cases at different stages of the appellate process?
For those cases, the court was equally clear. Where orders in original are challenged in high courts on jurisdictional grounds, assessees get 8 weeks to file appeals before Sestat. The same applies to cases pending before the Supreme Court. Assessees get 8 weeks to approach Sestat.
Sestat being the Customs, Excise, and Service Tax Appellate Tribunal for our listeners who might not be familiar with the term.
Thank you for that clarification. The court also addressed cases pending before Sestat itself. These should now be decided in line with this judgment. It's a comprehensive roadmap for resolving all pending disputes.
Let's discuss the practical implications of this judgment. How does this affect the day-to-day functioning of customs enforcement?
This judgment has huge practical implications. First and foremost, it restores DRI's power to investigate and issue show cause notices in customs matters, which had been severely curtailed by the original Canon India judgment.
And this is particularly important given DRI's role in investigating complex customs fraud cases, right?
Absolutely. DRI often handles sophisticated cases involving misdeclaration of goods, undervaluation, and complex duty evasion schemes that might not be apparent during routine customs clearance.
The judgment also seems to strike a balance between enforcement powers and taxpayer protection. Could you elaborate on that?
Yes, that's a crucial point. While the court has confirmed DRI's powers, it has also emphasized the importance of internal controls to prevent harassment. The judgment specifically notes with approval the department's policy of preventing multiple officers from issuing notices in the same case.
I think we should also discuss the court's analysis of self-assessment introduced in 2011. This seems to be a fundamental shift in how customs operations work.
Indeed, under self-assessment, importers themselves declare the classification, value, and applicable duty rates. The role of customs officers has changed from being primary assessors to verification authorities. This makes the original Canon India judgment's emphasis on the assessing officer somewhat outdated.
It's interesting how the court used analogies to explain complex legal concepts, like comparing it to self-grading in education with teacher verification.
Yes, and these analogies help understand why the original judgment's restriction of powers to the assessing officer didn't make practical sense in the current system.
Let's talk about future implications. How might this judgment affect customs administration going forward?
Yes, the court emphasized that matters of economic policy are best left to the legislature's wisdom. They cited the Bhavesh D. Parrish case to support this principle.
This seems particularly relevant given that customs duties and their enforcement are crucial aspects of economic policy.
Absolutely. The court recognized that while they have the power to review the constitutionality of laws, they should be cautious about interfering with policy decisions about how to structure and enforce customs regulations.
Let's sum up the key takeaways from this landmark judgment for our listeners.
The main takeaways are: first, DRI officers are proper officers under the Customs Act and can issue show cause notices. Second, the 2011 self-assessment system fundamentally changed how we should look at customs procedures. Third, validation laws like Section 2811 and Section 97 are constitutionally valid.
And importantly, the court has provided clear guidance for resolving pending cases, which should help reduce litigation and uncertainty.
Exactly. This judgment brings much-needed clarity to Customs Administration while maintaining appropriate safeguards against potential misuse of powers.
And that brings us to the end of today's analysis. We hope our listeners found this deep dive into customs law both informative and engaging.
Before we sign off, we'd like to remind our listeners once again to like, subscribe, and share our podcast. Your support helps us continue bringing you these detailed analyses of important legal developments.
And don't forget to tune in tomorrow for another exciting episode. Until then, this is Priya Mitchell.
And Arjun Kumar, signing off. Thanks for listening to the Ask Junior Daily Judgment podcast.